Right, hello, I'm Jeremy Johnson. I'm a member of Chambers at 5 Essex Court, which is where I did pupillage and where I've stayed ever since, and I don't know anything else.
I'm Naina Patel, and I'm a barrister at Blackstone Chambers, where I've been since I started my pupillage, which was in 2005. So probably not quite as long as Jeremy, but I too have also only known Blackstone.
All right, well, I was going to talk first, and I'm going to tell you a little bit about why I enjoy human rights work and find it stimulating and interesting and fulfilling. And I'll tell you a little bit about the sort of work I and colleagues in Chambers do, and a little bit about how we structure pupillage in Chambers. And Naina will then carry on, and I think she's going to talk firstly about how she came to the bar and that process, and then perhaps talk about a bit of the work that she does in Blackstone as well. All right, well, the different reasons that I enjoy human rights and public law work are, first, I suppose the law is in itself interesting, dynamic, rapidly developing. Whether it's a right to life case where the law has progressed from protecting individuals from state killings to preventing or requiring investigations into state killings, to requiring the police to protect people against risks to life. And the way that it's developing in that way is constantly challenging and interesting. Or whether it's a claim under the right to respect for private life under Article 8, which, as everyone knows, covers a huge range of activity, from, for example, restricting the manner in which police can retain DNA samples, or protecting end-of-life decisions about how people wish to choose to end their own lives, or fair trial rights, whether it's claims in respect of closed hearings with the secret courts proposals going through Parliament, or the burden of proof for marital coercion, which was topical last week. It's a dynamic and, as I say, constantly developing and challenging area to work in. But it's not just the dry legal academic field. The facts are also almost always really compelling and full of human interest. So you have the combination of challenging law and interesting facts. But also the colleagues one works with, the opponents that one comes across, are almost without exception very driven. They come up with inventive and challenging arguments, and it is always, I find, a stimulating field to work in. And of course the cases tend to come up in the senior courts, usually in the administrative courts and the appellate courts, so one is very often in front of the senior judiciary. The cases are often of wider public importance. Of course, all or most legal cases are of significant importance to at least one of the participants, whether it's a through case challenging a withdrawal of benefits or a family case about contact with children. But one of the features of human rights litigation is that the cases often have wider policy implications and a wider application than is relevant simply to the participants in that case. And they're often always, of course, pretty high profile, as the front page of most daily papers will testify to. In Chambers, we generally act for defendants to human rights claims, whether it's the police or government departments. And that provides an opportunity to assist in the development of policy in a way that respects human rights, and to ensure that government departments and the police, when carrying out their functions, that they can do what they want to do, but in a way that's consistent with human rights norms. And that's quite a challenging but interesting area of the work. As the sort of work we do in Chambers, I've just started the Al-Swedi public inquiry into torture and allegations of torture and murder of Iraqis by British military in detention. And a colleague in Chambers is doing that as well. We've done other international human rights cases, such as challenges to the withdrawal of the right to trial by jury in the Turks and Caicos Islands, which very sadly was heard in London rather than at the much more appropriate venue, Turks and Caicos Islands, and rules for determining which European countries are responsible for assessing a particular asylum claim, for example. But more usually we deal not with international human rights claims, but domestic claims. For example, challenges to mental health legislation and its compatibility with the European Convention of Human Rights, challenges to the way sex offenders are treated and the registration requirements for sex offenders, and quite a wide range of challenges of that nature. But the core area of work in Chambers, and what we're best known for and what we did historically before human rights were even invented in 1998, is acting for the police, and of course that's developed a much greater human rights focus. So for example, challenges to the use of stop and search, challenges to the disproportionate number of black Londoners who are stopped and searched under the legislation, challenges to the retention of photographs, the photographing of protesters at demonstrations. And also quite a large number of the high-profile inquests and public inquiries. So the Mark Duggan inquest that's coming up, the Hillsborough inquests, the Azelle Rodney public inquiry, Al Sweeney I've mentioned, and then in the more distant past, cases like the Macpherson inquiry and the inquests into the deaths of Diana, Princess of Wales, and Dodi Fayed. So that's the sort of areas we cover. Of course, pupils and junior tenants aren't thrown into doing those sorts of cases on their first day on their feet, although, as it happened last year, our second six pupil, her first case on her feet on her first day of her second six, ended up being in the Court of Appeal against a Silk in a pretty difficult human rights case. But we don't plan it like that, and we won't intend to do that again, even though she was gloriously successful, and it's given her a wonderful war story to tell. But more normally, pupils and junior tenants tend to work as juniors to Silks in Chambers and senior juniors in Chambers on the larger cases. But also we expect pupils and junior tenants to have their own caseload, doing cases in their own right, whether that's claims for sex offender prevention orders, for example, in the magistrates' court, or defending the police or government against allegations of abuse in prisons and police stations. We give our pupils 3 different supervisors during the year, so they see the breadth of Chambers work. We have a weekly talks programme for pupils and junior tenants. So each week, one member of Chambers will give a half-hour or 45-minute presentation on any one of a huge range of topics, from narrow questions of law, which are topical at the moment, to how to deal with a difficult opponent, to how to deal with a difficult judge, for that matter. So that we hope that by the end of the year, there's been a pretty rounded education. And then, as I say, we expect pupils from the start of their second six to be on their feet, not doing cutting-edge human rights work in their own right, but very often being involved in that sort of work as a junior or a member of a wider team. We also quite often have juniors and pupils spending a small amount of time in-house with one of our client solicitors, so they can see the work from a different angle. So that's all I wanted to say to start with. We can have questions at the end, but if I hand over to Naina now, she'll tell you about it from her perspective.
So as Jeremy said, I propose to talk a little bit about how I got to the bar, in case it helps your decision-making process about whether to do master's degrees in law or in any other subjects. Our system at Blackstone, which is a little different to the one that Jeremy's described, so again gives you a sense of the sorts of different ways of organising pupilages that are out there in different chambers. And then finish off with a little bit about the human rights work that I do, which again is a little bit different to the sort of work that Jeremy has described, so we'll just give you that range of perspectives. I went up to read law at university. I switched after 6 weeks and I decided to do PPE instead, not because I wasn't interested in law, but because I decided that for me those 3 years wasn't the time to do it. I then did the CPE on graduation at City, and I then went off to read for a master's in primarily development, economic development, and some international law. I did that at Harvard, so I had the benefit of a number of graduate schools and being able to mix and match courses. I think at that time you couldn't do a law master's in the States, so that was one of the factors that fed into my decision making. But also I just happened to be interested in development economics and wanted to study it more, and took the view that I'd weave law into that as I could, but I wasn't going to make that the focus of my master's. And again, for me that worked. I think that educational track record probably indicates a couple of things. I was interested in policy issues of the kind that Jeremy's described from quite young, how institutions of politics relate to one another, how the economy works, philosophical questions about moral responsibility, and that sort of thing. And I was also interested in overseas experiences, hence the study in the US. And while I was at Harvard, I got the opportunity to spend a summer working in Afghanistan, which was back in 2003, shortly after the intervention had taken place. And again, that was, I think, where a lot of my interests in foreign policy issues began and have continued from. So you could probably see from some of those choices that I might have had the sort of interests that might have led me into the sort of human rights area at a later date, but I don't think at that stage I knew that was where I was going to end up. After my master's, I did the what's now called the BPTC. In those days was the bar course, the bar vocational course, and then I came straight to Blackstone for my pupillage. And our pupillage was then structured and is now still structured around a number of seats like Jeremy's described. Ours tend to be in each of what we would consider to be our 4 main practice areas, one of which is public law, where a lot of the human rights flavoured cases will obviously be, another of which is EU law, which would include competition law, commercial law, and employment law. And the reason our pupillage is structured like that is because in the early years of practice, the first 3, 4, 5 years at Blackstone's, we very much do expect all tenants to be doing cases in all of those different areas, and there are a number of reasons for that that I'll come to in a minute. I think the takeaway from that I'd like to put across to you is that actually, from my perspective and from the perspective of a number of people in chambers, human rights actually runs through all of those areas of law. And one could have an interesting debate about whether the term human rights lawyer is or is not a misnomer. It's often the case that public law cases will raise human rights issues because the Human Rights Act obviously places obligations on public authorities to comply with the Act. But it's also the case that EU law can raise points around human rights, increasingly so given the EU Charter that's now come into force. Similarly, commercial cases can raise human rights issues, and I'll give you a couple of examples in a moment. And even employment issues can raise, particularly in the discrimination context, issues around freedom of religion, the ability to be free with your sexual orientation in the workplace, and so on. So across all of those practice areas, whether you're a pupil or you're in your early years of practice and you're working in those 4 areas, you may be encountering human rights points. They may not be explicit, but after close examination of the papers, you might spot a human rights point that perhaps wasn't in your instructions, or perhaps wasn't even something that the client had identified, but is potentially arguable and potentially winnable on. One of the reasons why that mix is so important is because certainly in our experience, some of the issues of law, topics of law like regulatory law, involve very much both skill sets from the commercial side and skill sets from the public side, including some human rights experience. So take something like the decision to revoke a license from a utility company. A license is obviously a contractual relationship, so commercial law is obviously of relevance. But what's also relevant is the process by which there may or may not be consultation with the person whose license is going to be revoked, and the principles on which that license will or won't be revoked, all of which are very much public law elements, and you can see immediately that things around having a fair hearing and Article 6 might be of relevance. So I think particularly in the regulation and competition aspect of things, both public law and commercial law skill sets can be useful. And we take the view that in getting a very solid training in all of those areas of law, you'll be well placed to then A, make the decisions about whether and how you want to specialise later on, but B, you'll also have a very broad toolkit from which to make some of the creative decisions that Jeremy's alluded to that are involved in human rights law, thinking outside the box, working out how best to tackle a legal problem in a creative way, perhaps a way that people haven't done before. Another reason why that range of practice areas in the early days works for us is because, as Jeremy's alluded to again, a lot of the public law work is in the senior courts. And while that's fantastic when you can have the access to senior courts and to high court judges and above, sometimes in the early years of practice, Jeremy's most recent member of Chambers was obviously very lucky to be in the Court of Appeal very soon after. I'm sure she didn't feel so at the time, but it may be the case that in the early years of practice, you don't have sufficient access to advocacy opportunities in the higher courts. And there are ways and means that Chambers use to increase your advocacy opportunities. The way that we do it is through doing work in the commercial area. There are a range of opportunities that are available to you in county courts that can allow you to get a really solid grounding in advocacy in a commercial context. Similarly, in the employment context, there are lots of opportunities in employment tribunals. In the more public law side of things, there's obviously the asylum and immigration work in the first tier tribunal and the upper tribunal. So there are a range of ways in which you can get that very important experience in court, cross-examining witnesses, making submissions in your first 3-4 years, some of which are in the courts that will deal with public law issues, but some of which are not. And so for us, that broad mix allows you to have maximal opportunity to be getting into court and getting your flying hours, as it were, in being an advocate. So just finishing then with a little bit on the sorts of human rights cases that I have done in practice. I've been in practice for 6 years. I became a tenant in 2006. I took a sabbatical year away actually to go back to Afghanistan and do some work there. So I've only had 6 years or so doing cases. But in that time, to give you a flavour of, again, as Jeremy said, the range of different areas in which human rights cases and issues can arise, I've done a couple of cases that have involved religion. Again, very diverse. One in a media context. It was a challenge to the BBC's decision to broadcast Jerry Springer the Opera, which at the time was said to be in contravention of the blasphemy laws that have now been repealed. That was my moment of terror. I think I was in my first or second year, and I had David Panic, fortunately as a co-defendant rather than against me, but another Silk on the other side. And I was all alone and, you know, a very recent tenant, but survived and lived to tell, hopefully, a fairly interesting war story. And more recently, I've been involved acting for the Scientologists, which is actually in the marriage context, but it's about the, there was a hearing in December in the High Court. It's about the basis on which one can have legally recognised marriages and the different religious denominations that legislation currently permits you to have legally recognised religious marriages without the need for a separate civil ceremony. So media law, marriage law, already a very strong contrast there in terms of subject areas. A couple of immigration matters. One immigration case at the moment concerns a chap who's been in detention for 3.5 years because he doesn't have a travel document to go back to his home country. And the Home Office is not convinced he's from where he says he's from. Another case that involved the test that should be applied in granting asylum to people who are fleeing persecution on grounds of their sexual orientation. A couple of cases in the regulatory context around tobacco and the display ban that came into large supermarkets last October that doesn't allow you to display cigarettes anymore, and the implications of that for the right to freedom of expression for commercial manufacturers of different goods. cases around licensing in the utilities context that I've alluded to, cases with an international flavour, Al-Skaney, which was one of the precursors to the Al-Swedi case that Jeremy's acting in at the moment, which was about the extraterritorial application of the Human Rights Act to Iraq, the licensing of arms exports to Palestine, and the extent to which we do or don't comply with the criteria that we are meant to comply with. So a very broad range of topics, again, that you can see where these issues arise. I think I want to finish by just giving you a couple of commercial cases to make good the point I made that these points really can arise in a whole range of contexts. The case that related to Guantanamo, British nationals in Guantanamo detention, Al-Rawi, and that's now led to this legislation that Jeremy alluded to going through Parliament about secret courts, was a case called Al-Rawi that many of you may be familiar with, which went to the Supreme Court a couple of years ago on this topic of whether or not there could be a closed court procedure. And that was clearly a case that involved serious human rights issues around whether or not there had been complicity on the part of the government in torture. It wasn't framed as a Human Rights Act claim. It was in fact civil litigation. It was a civil claim for damages, effectively a tort claim, saying that complicity in torture is effectively a type of tort. But it obviously raised important human rights issues about what had happened to these men and how, and who had known about it at the time and who had condoned it. Another example is the case of Binyam Mohammed. Binyam was one of the detainees in the Al-Rawi case, and again, you may well have seen his case in the newspapers. That was a case that involved the use of a commercial law remedy called a Norwich Pharmacal application, which is a type of disclosure order that you can use to get information from someone who's not party to the proceedings in particular circumstances. And that was effectively the use of a commercial remedy in a judicial review public law context. Very novel at the time, since, as I think I mentioned to someone earlier this morning, since overruled by the Court of Appeal very recently in a case called Omar, who said that's not an appropriate use of that remedy in this context. But at the time, crucial for helping Binyam in getting these documents which were so crucial to his defence and ultimately his release. And lastly, the case that I was involved in last year, a fraud case which effectively relates to the fraudulent, the taking of assets from Moldova in the context of very curious court hearings that appear to have never taken place. So doctored court ledgers, doctored court orders, and allegations that very senior members of the judiciary in Moldova have apparently been complicit in a whole raft of things taking place untowardly in the courts, which raise obviously very serious Article 6 rights, off the back of which there are Strasbourg applications afoot, but off the back of which also there were some commercial applications for injunctions last year in relation to trying to safeguard some of the assets. So again, a very broad range of subject areas where human rights issues can come into play and where some knowledge and understanding of how human rights litigation works is very important, but where probably far more important is a grasp of the particular subject area of law, whether that's commercial law, employment law, public law, or competition law, coupled with an eye to spot these points and to know what to do with them when you see them. So I think I just finished by saying, if I had 3 sort of lines of advice for you, if you are genuinely interested in this area and it's an area that you want to go forward in, focus first on becoming a very brilliant lawyer. Decide what area it is. If it's public law, brilliant. If it's employment law, brilliant. If it's commercial law, brilliant. And focus on your skill set and on really knowing your subject matter. Along with that, focus on understanding the Human Rights Act, which is as things stand at least, the main way in which the Human Rights Act comes into play here, and focus on being able to spot those human rights points when they come up, whatever context that is, whether that's prisoner work, mental health work, commercial work. And in terms of how you get there, lots of people have been saying over the course of the morning, I'm not sure whether to do this master's, I'm not sure what work experience to do, I'm interested in going abroad, but I'm worried about what that might do to my application. Follow your heart. If, like me, you have a quirky interest in development economics and that's what you want to do that, come to the bar later. You know, if you've got a burning desire to do a master's in law and in intellectual property law, although you're not sure that that's where you want to end up practicing, go and do that. You know, follow your heart and follow where your interests are, and the rest tends to work itself out. I think when you follow your heart, you do what you're interested in and what you enjoy. You tend to do well at it. You tend to excel, and ultimately you tend to end up in the place where you're meant to be.